Hey, good morning. I just wanted to share a great story of a very strong advocate in America. Her name is Serra Frank, and is fighting for medical and legal justice in a state that is hostile to cannabis and the people who depend on it. Very common story, but this story is supported by lots of people for Serra Frank, and you can support her on her Facebook page, Mums for Marijuana in Idaho Mums for Marijuana, and also Compassionate Idaho. Now, the story starts from an article from hightimes.com by an A.G. Harrington 3 days ago. So let's go through that story. Hello to everyone from Hemp Gold Coast. My links are below. Stay updated. An Idaho cannabis activist is scheduled to appear in the state of district court on Thursday for oral arguments in her appeal of 3 marijuana possession convictions. Serra Frank, a medical marijuana patient from Boise, is fighting to have her convictions overturned on the basis of medical necessity. Frank has a serious bladder condition known as interstitial cystitis, I think it is, which causes severe and chronic pain for her. She describes in an interview with High Times the effects that the condition has on her health. My bladder doesn't expand properly, Frank said. When a healthy bladder fills up, it expands like a balloon. Mine doesn't. Instead, it stiffens and cracks and bleeds, kind of like an inner tube that's been left out in the sun. Interstitial cystitis, I'm not saying it right, but you can read the article below, affects some patients so severely for so long it is classified as a disability by the Social Security Administration and can have a devastating impact on those who live with the disease. The quality of life for people with my condition is so severe that we are 3 or 4 times more likely to commit suicide because of the chronic pain, said Frank. We've lost a lot of people that way. There is a known cure for this, and traditional treatments such as opiates, analgesics, and anti-inflammatory drugs can have varying degrees of effect and often come with serious side effects. Since 2004, Frank has chosen to treat her condition with cannabis, the medicine that provides the most relief for her. Even with it, she is in pain on a daily basis. But cannabis allows her to function in a busy life, which includes being a mother of 3 children. For Frank, using her medicine of choice comes with a risk. Idaho has no provision legalizing any forms of medical marijuana. She's been working for change in cannabis policy for more than 10 years and is involved in groups including Idaho chapter of Mums for Marijuana, Compassionate Idaho, and Boise Hemp Fest. Arrested at protests. To gain support for legalization, Frank and others organized smoke-out demonstrations that was to be held on the steps of the state capitol building in Boise on New Year's Day 2016. 3 days before the protest, Frank was a passenger in a vehicle that was stopped for a traffic violation. During the encounter with the law enforcement, she was searched and her medicine was discovered by police, who arrested her for possession of marijuana. She was also charged with obstruction for initial refusal to exit the car and submit to a search without a warrant. Frank admits that she was angry with the situation and says she was determined to commit an act of civil disobedience at the planned protest. Idaho State Police, who have jurisdiction at the Capitol, had been informed of the group's plans in the interest of carrying out a peaceful protest. Before Frank could even light her joint at the demonstration, Idaho State Police intervened and said they would not allow Frank to spark up. Instead, she surrendered her medicine to the officers and was taken into custody. At her trial, Frank had hoped to present evidence to the jury of her condition and the medical necessity for her to use cannabis and possess it at all times. However, despite a 1990 Idaho Supreme Court ruling that found a defendant in a marijuana cultivation case was entitled to present evidence of such a defense, the judge in Frank's case ruled that her doctor could not testify on her behalf. She was not allowed to present any evidence about her health problems, including documentation from doctors in Washington, Oregon, that concluded she could benefit from medical marijuana. I have had a medical recommendations for cannabis before, but they wouldn't even let me talk about any medical condition in court, Frank said. Without the right to present defense of medical necessity at a trial, Frank was convicted on 3 counts of marijuana possession and 3 counts of possession of paraphernalia, although the jury acquitted her on the obstruction charge. She is appealing the convictions based on the judge's decision to deny the presentation of evidence of her medical condition and to instruct the jury on the medical necessity defense. If her current appeal in the State District Court at Ada County is denied, Frank plans to take her case to the Idaho Supreme Court. Her sentence of probation, fines, and suspended jail term has been stayed by the court during the appeal. While waiting for the appeals process to go through the court system, Frank has moved to Oregon, where she can obtain and use her medicine legally. But even as a medical marijuana refugee, she continues her work for cannabis policy reform in her home state, including work with Legalize Idaho. The coalition of activist groups is campaigning for a recreational marijuana legalization initiative and plans to complete a petition to put a measure on the state ballot in the coming weeks. Frank says she is still upset by the situation in her home state, but she wants to return so she can be closer to the rest of her family, including her parents. Idaho's home, she replied. I like to go back there. I feel like I'm in exile here. But until at least the medicinal use of cannabis is legalized, she plans to stay in Oregon. Unfortunately, Idaho is bad for my health, she said. I have some links on support of Serra Frank, and just Google. There are lots of articles that talk about that, and I'm going to share some of them here for you. There's more information here from Weed News. You'll find all the links down below, and I'll just share some of her thoughts. She goes on to say, in December I submitted my own motion and still denied a defense to reconsider, and was again denied my right to present evidence as to necessity, including a doctor as an expert witness, despite my request in accordance with the common laws of England recognized by the Idaho Supreme Court and Idaho state laws. Judge says that while I do meet most of the elements of the necessity defense, he doesn't feel I meet the requirements of immediate threat of harm. So he has now twice denied me the defense against the 6 marijuana-related charges and 6 years in county jail I currently face. Yet, as stated above, the Idaho Supreme Court has already ruled that it is up to the trier of fact, the jury, not the judge, to determine if the elements of the defense are met, and that I have a right to present evidence of the defense to a jury. Plus, the judge is not a doctor. It is not up to him to determine whether my condition contains an immediate threat of harm without my choice of medicine. My medical choices are between me and my doctors, not the state of Idaho. The threat of harm is very real in my condition. The physical and emotional pain is very real for millions of Americans, so much that those with my condition are 3 or 4 times more likely than the general public to choose to take their own life than live with the pain. Indeed, we have had many of the intestinal cystitis community lost by their own hand in recent years. The impact on quality of life is so severe, some would rather choose to commit suicide than live in the kind of agony and misery. A Harvard University concluded the quality of life of those with this condition is comparable to those on the kidney dialysis and those with chronic cancer pain. I had neither and have no way to compare pain, but as a friend so kindly points out, severe pain and dysfunction is a harm. That's why people win millions of dollars in settlements for pain and suffering. But I see what is happening. I can see where and most likely why Idahoans who request the necessity defense when charged with marijuana offenses because of their choice in medicine are being denied and coerced into plea agreements. A recent Idaho Supreme Court ruling declared there must be a reasonable view of the evidence to support the theory of necessity. This was said in response to a case where a man was traveling through Idaho and brought with him over 3 ounces of marijuana, and the court ruled that there was not evidence to support the theory because he had alternative choices for pain relief during the 8 hours of travel through Idaho. But now it's being used against the citizens of Idaho too. This is what the judge is using to deny my defense, because apparently to him, 15 years of medical history, numerous written doctors' recommendations, and the testimony of a very credible expert witness are not considered a reasonable view of the evidence. And when the public defender's experienced attorneys are denied the necessity defense for their client, they don't appeal, instead convince them to plea out in order to avoid jail time. This definitely needs to be challenged, and luckily I'm in a place to challenge it. Unfortunately, that means going forward with trial without a defense, so I have a judgment from which I can appeal. So I will do my best to defend myself while simultaneously being denied a defense. After more than 2 years of observing the apparent joke that is our criminal legal system in Idaho, they finally put a trial date on the calendar. Wednesday, the 7th of March, 2018, in just a few weeks. I will be denied my constitutional right, due process, and will not be allowed to present my side of facts or present my defense to a jury of my peers. Instead, the Idaho County prosecutors will parade dozens of police officers and drug experts into the courtroom in an attempt to make me look like a criminal and take me away from my children to lock me in a cage while I will suffer unimaginable physical pain when I'm not allowed my medicine because of Idaho law. All over the invocation of my rights to an Ada County sheriff, 3 grams of marijuana, and my involvement in the civil disobedience process that followed. I could definitely use your support. If you can make it to the trial, I will appreciate your support in the audience. And there's the date, March the 7th, in Idaho. There's an event page, and we'll go to that shortly. She's also asking for donations to support her defense. And if I win, I will need to fight the charges all over again with an expert witness. I am in need of funds to help cover appellate court costs, witness travel costs, and witness fees. Idaho is one of the 3 states in the nation that persecutes its citizens for all forms of cannabis. There are numerous reform efforts happening in Idaho. We need your help we can get. So there is a link to this article where you can sign the petition, donate to her defense fund, and there's an event page, so we'll go see that shortly. Let's go to some of these pages here. So here's the court support for Serra Frank, March the 7th at Ada Court. If you're interested, you can follow the details, and I will update. So on December 27th, 2015, Serra Frank, founder of Mums of Marijuana International and co-founder of the Fight for Lily Foundation, was a passenger in a vehicle in her home state of Idaho when she was arrested and cited for resisting and obstructing after invoking her Fourth Amendment right not to be searched without warrant. Serra was also charged with possession of controlled substances and possession of paraphernalia for the medical marijuana found in her purse after her arrest. Each charge carries up to a year in jail and a $1,000 fine. January the 1st, 2016, Serra joined Idaho Mums for Marijuana in a rally against the harmful marijuana laws in Idaho at the first annual New Year's smokeout at the Idaho State Capitol. Serra was the only one cited for possession of a controlled substance for a joint she planned to light in a protest of her charges and Idaho's harmful laws. She was also charged with possession of paraphernalia for the joints container. On January the 1st, 2017, Serra was cited again for both possession and paraphernalia at the second Idaho Mums for Marijuana New Year's smokeout. On January 1st, 2018, at the third annual protest, Serra gave the Idaho State Police legal drugs instead: coffee, donuts, and cigarettes. For the last few years, Serra has been fighting for the right to use the necessity defense against these charges because of her medical disability, chronic and painful bladder condition called interstitial cystitis. Despite a 1990 Idaho Supreme Court ruling allowing the necessity defense against marijuana charges, Ada Court Magistrate Judge Michael Oths has denied her defense. Serra has repeated herself in court on March 7, 2018 without being able to present any defense against marijuana charges. She plans to appeal any conviction. Please join her in court in support of her Idaho marijuana laws. If you can, be sure to let the state of Idaho know what you think of their opinion. Okay, so that link of that page you'll find down the bottom. Then there's another one here, call to action to support CBD exemptions, hosted by Legalize Idaho. Okay, so that link will be down there below. And here is the Legalize Idaho page. A community effort to reform Idaho's former outdated marijuana law. And here's another one here, sign this petition. The link will be down below, Legalize Idaho. Want to reform harmful, okay, so you can read that down there. So, reasons for signing. It's a plant right, come on. Let's read this one. Let me just read this one here. It is a plant put here by God for us to use. I had no known deaths is safer than alcohol being illegal. The amount of people who actually use it and get caught had many negative impacts to your family and individual lives. A criminal record for cannabis use and consumption destroys housing opportunities, jobs, and persons' well-being financially, putting undue pressure on a person's life. It should not be a crime to use cannabis. It is a constitutional right of freedom of choice in life, liberty, and pursuit of happiness. There is no crime of free choice as long as it doesn't infringe on others' rights. If you commit a crime after while using cannabis or after using, then you should be convicted of that crime. Cannabis is known to be a drug of choice. Well, so is caffeine, chocolate, cigarettes, food, sugar, alcohol, adrenaline, soda, inhalants, gas, paint, glue. Should we make all this illegal because it was a person's choice to use and it's becoming an addiction? Okay, so all of that information is down there. Thanks for watching my video here in search of supporting Serra Frank and fighting for her medical legal justice in a state that is hostile to cannabis and the people who depend on it. You'll find all the links below. If you're able to support her on her Facebook page, which is, I'll have the link down below, court support for Serra on March the 7th, then please join if you're able to support her defense donation or go to the event page, that will be most welcome to her. I don't know her, but I found that the story of people who have painful conditions, and I know here in Australia there are a lot of people in that condition who have to drive. I live here on the Gold Coast in Queensland, and a lot of them are, are driving to, say, Nimbin in the Gold Coast, which has a place there, the Nimbin Embassy, which do great work providing support and counselling, and also medical marijuana as such. Well, I wouldn't say it's a medical marijuana, but it's natural. Have had a lot of experience, and a lot of people drive at their own risk for the pain. And a similar story here, cancer, and it's not legal here in Australia, but she aptly describes the pain that has driven a lot of people who suffer pain to take their own lives, and have the right, after getting some relief or remedy, to seek wherever they can to continue to receive that support. So I did this video basically to support the many people out there who are driven to seek relief from pain by using marijuana. And this story, I'm not too sure if it's similar here in Australia, but I know at the conclusion that a lot of people who have been convicted of marijuana, cannabis possession, has limited the options in their life here. And as described previously, what I read out, these convictions are with them for the rest of their life and create stigma. And sometimes there's a barrier to employment, the stigma involved. So I'm hoping you can support anyone, or if you have views, please write them down below. I'm not too sure whether you believe that currently supporting medical opiates is the proper way to continue to support people who want to get relief from pain, and for natural plants as such to have this amount of attention and legal armory to stop people like Serra to provide evidence to support her condition is amazing to me. The courts here in Australia and New Zealand are filed with so many people. I would dare say a lot of the staff could see the massive amount of time and energy taken up by our systems of people who are convicted for possession, where this time could be rarely not be used. I don't know what would be the percentage in our court system that is cluttered with these offences. Anyway, those are my thoughts. Thank you for watching. Click on the links below, and I hope these have been of help to you. This is Fraser Goodman from Gold Coast. Thank you for watching. See you in the next video.